Hello and welcome back. John Crotts, attorney at King Law and certified elder law specialist. Uh, Wanted to talk to you today about what happens when a loved one can no longer make decisions for themselves. Well, in North Carolina, that's where incompetency and guardianship proceedings come into play. I want to give you a quick overview of the legal requirements and the procedural steps of guardianship and incompetency in North Carolina. And I want to tell you a little bit about powers of attorney and how they can help avoid this process altogether. So, first, let's talk about the legal requirements for incompetency. Incompetency is essentially when a person is declared legally incompetent because they lack sufficient capacity to manage their own affairs or make important decisions. Now, any interested person can file to seek the declaration of incompetency. It can be family, friends, or even the local Department of Social Services. The clerk of Superior Court in North Carolina is the one that determines incompetency based on the medical evidence, the testimony, and the evaluations that may be submitted in evidence during the hearing. The procedural steps to get started on a guardianship case or an incompetency case is to first file the petition that is submitted in the county where the respondent or the alleged incompetent person resides. The court will then appoint a guardian ad litem, which is an advocate, typically a local attorney in the area, who will represent the alleged incompetent person's best interest. This guardian ad litem will do a thorough investigation, meeting with the petitioner, any other interested parties, family, certainly the respondent, and that guardian ad litem will ultimately give a report to the court with recommendations on whether or not he or she believes that this individual should be declared incompetent and whether or not they believe a guardianship is in the best interest of the individual. The hearing process is basically it's a bifurcated hearing. The court generally will start by entertaining evidence pertaining to the incompetency and evaluate the medical and expert testimony that's presented. Family and interested parties can also provide input at that time. The clerk will decide if that individual is incompetent, and if so, the court will determine what type of guardianship is needed and who is best suited to serve as guardian. Now, there's a few different types of guardianships. There's a guardian of the person, which is an individual appointed to uh, handle the health care and personal decisions of the individual. There's a guardian of the estate who may make financial decisions and manage property and assets for the individual. And then there's a general guardianship, which manages both personal and estate matters. The court has to pursue or explore the least restrictive means available for taking care of the respondent. And in some cases, the court may order what's called a limited guardianship, where an individual may need assistance with certain areas of their life, but continue to live independently and be able to manage their own affairs in other areas. The court will require the appointed guardian to file ongoing reports with the court to ensure accountability. So there will be ongoing court oversight throughout the guardianship during the lifetime of the guardian. Now, as I mentioned earlier when the video started, there's the ability in a lot of cases to avoid these guardianships altogether through powers of attorney. A properly executed power of attorney will allow someone that you trust to handle the financial and health care matters if you become incapacitated. There's generally two types of powers of attorney that we uh, execute. There's a durable power of attorney that allows someone to manage assets, bills, and financial decisions. Then there's the healthcare power of attorney that allows someone to make medical decisions on your behalf. And having those powers of attorney in place saves time, saves money, stress, and provides peace of mind by preventing the need for a court-appointed guardian in most cases. So guardianship can be a long and emotional process, but with the right planning, like having a power of attorney, you can protect yourself and your loved ones. So if you have questions about guardianship, powers of attorney, or anything else pertaining to elder law or estate planning, give us a call at King Law or visit us at kinglawoffices.com, and we'd be delighted to have an opportunity to meet with you to discuss your situation. Thanks.